Ladies and gentlemen, good afternoon, good evening, and good morning. Thank you so much for taking the time out of your busy agendas to listen in and to participate to this really important discussion we're going to have with two highly relevant and informed individuals, namely Ambassador Ranjit Ray and Professor Andras Vamos-Goldman. The theme of our discussion today is framed around international humanitarian law as the cornerstone for international peace and security. But before we start, I would just like to set the context of what do we mean by international humanitarian law? It is best understood as a set of rules that seeks, for humanitarian reasons, to limit the effects of armed conflict. It protects persons who are not or are no longer directly or actively participating in hostilities and imposes limits on the means and the methods of warfare. IHL is also known as the law of war or the law of armed conflict. IHL is also part of public international law, which is made up primarily of a number of treaties, customary international law, and general principles of law, specifically Article 38 of the statutes of the International Criminal Court of Justice. So before we get this really interesting discussion going, I would kindly ask our panelists to introduce themselves and also then immediately do their opening statement in terms of what are your interests and your insights when it comes to international humanitarian law. And I give you the word, Ambassador Ray.
Well, thank you very much. Greetings, and it's a great pleasure to be on this webinar. My background is, I spent about 36 years in the Indian Foreign Service, and about half the tenure that I had dealt with multilateral and United Nations issues, either at headquarters or at the Permanent Mission of India. I'm an Indian diplomat. Or at the United Nations. I also worked for the UN mission in Kosovo. And my experience was more on the peacekeeping side, on budgetary and administrative matters. I was a member of the Advisory Committee on Administrative and Budgetary Questions. And the other half of my career was really in the bilateral foreign service, but I had, an interesting tenures in post-conflict countries. I was ambassador in Hungary when I was also looking after Bosnia and Herzegovina. And, while Dayton brought peace to Bosnia and Herzegovina, I think it has set up a very unwieldy government structure. Thereafter, I was in Vietnam, which is also a country that has done exceedingly well after the horrible experience of war in the 70s. And lastly, in Nepal, which has gone through its own insurgency. There was a communist or a Maoist insurgency in the country. And I was associated with the whole peace process and subsequent developments. So it's been, so my experience has really been on the conflict resolution, peace and development continuum. And I think in this context, the international humanitarian law plays such a critical role. Post-retirement, I have the good fortune of being on the Peace Advisory Board of UNITAR. And coincidentally, I'm also a member of Diplomats Without Borders since last year. So I'm actually wearing two hats. Once again, a pleasure to be here.
Thank you so much, Ambassador Ray, and it's really an honor for us to have you as part of this discussion. Professor Andras Vamos-Goldman, please.
Thank you very much, and big hello to everyone who has joined the webinar, and thank you to UNITAR for making this discussion possible. I've also spent the majority of my career in the Foreign Service, in the Canadian Foreign Service, in various postings, including about half of my career in multilateral work. So I was posted in New York to the Canadian mission to the United Nations, and I had the great fortune at that time to be part of the delegation that was the last Canadian delegation in serving in the Security Council of the United Nations. It was at a very interesting time in the work of the United Nations. It was 1999 and 2000. Coming to the end of an extremely active decade where multilateralism was blooming, states were cooperating. They saw the multilateral fora as a vehicle in which they can achieve their own means, but also to advance the global good. It is an era that is unfortunately past at the moment. It's we're not there, but it is interesting to reflect how that decade impacted on international humanitarian law. Just to finish a little bit, afterwards I was one of the founders and then the executive director of a hybrid organization. Certainly had international elements, certainly had non-governmental elements, called Justice Rapid Response. It's an organization that whose aim was to improve the professional application of international criminal law by providing trained professionals from every part of the world to the international community, to whoever had the jurisdiction to investigate genocide, war crimes, crimes against humanity, or core international crimes. And it was a fascinating view, kind of from the other side, not from the side of the states or international institutions so much, but also from the non-governmental side of the international community. So I feel that I am very fortunate to have had such a full and an interesting career, and to have been able to work at a time when multilateral progress was possible. If Mr. Chair, if you would allow, I will jump in a little bit with to expand a little bit on your excellent introduction of what international humanitarian law is, and maybe to get our discussion kickstarted. Would that be okay?
With pleasure.
All right. So international humanitarian law, as you absolutely correctly described, is a body of laws that we have worked on steadily since, I think maybe a good start for it would be the Battle of Solferino, when Henri Dunant saw the effects of unmitigated warfare and kickstarted the International Red Cross movement. This was in 1859, and so since then, let's call this the modern era, where work on trying to mitigate the worst effects of organized violence When I teach international humanitarian law, this is how I explain it to my students. Mitigating the worst effects of organized violence. Because we very often put greater expectations on international law and indeed multilateralism than those laws and those processes were meant to carry. So international humanitarian law is not there to eliminate human violence. It's just there to be, as I said, and I really like this phrase, mitigating worst effects of organized violence. Maybe at the outset, it's important to make a distinction between jus in bello, which is international humanitarian law, which talks about the means by which armed conflicts are fought, and the essence of international humanitarian law being that whoever is fighting does not have unlimited choices in either the means or the methods with which that the use of force or force is used. They are in fact limited. They are limited in two, broadly speaking, two ways. I like to put them into two categories: the Hague Rules and the Geneva Rules. The Hague Rules talk about the means, the materials that you can use, whether it's the limitation of chemical weapons or the limitation of mustard gas or the kinds of munitions. So a variety of conventions, which ended up in some parts codifying conventional or customary international law to limit the weapon systems, materials that can be used. And then, of course, the Geneva Conventions. The Geneva Conventions talk about who are the people who are going to be protected, who would be protected in these situations. There are 4 Geneva Conventions, as we, I think, all know, protecting wounded soldiers, shipwrecked sailors, prisoners of war, and then civilians or non-civilian non-combatants. There are 2 additional protocols. One, the Geneva Conventions, apologies, stem from 1949. The additional protocols came in 1977. One is to deal with international armed conflict, and the other deals with non-international armed conflict. And they specify and clarify some of the rules that first were codified in the Geneva Conventions, and maybe even expand on them a little bit. So that's jus in bello. Jus ad bellum, which is not international humanitarian law, deals with the right to use force. That's all it is. It is, does the state or an entity have the right to use force? And ever since the United Nations Charter exists, there is very little doubt about the only 2 circumstances in which states or other entities have the right to use force. One is when the United Nations Security Council permits and so authorizes, not just permits, but so authorizes the states to do so in Chapter 7, Article 42. And the other situation is also in the UN Charter, Article 51. It's the right of individual or collective self-defense. So when a state has been attacked. And I say that this is straightforward and simple and clear, but it isn't. The devil is in the detail, and there are lots of details in both of those. Today, I think we will be speaking only about jus in bello, so the means by which force may be used, as opposed to jus ad bellum, which is the right to use force. And maybe at this point I will stop and turn it over back to you, Mr. Moderator.
Thank you so much, Professor Vamos-Goldman. It was really interesting to get that framework to anchor the discussion, and thank you also very much for building on the difference between and the distinction between justum bello and the public international law, that is the jus ad bellum. Thank you very much for that. Ambassador Ray, if I may draw you on your experience, please. And Professor Vamos-Goldman mentioned the element of international armed conflict and non-international armed conflict. Could you please share with us, when you were based in Bosnia-Herzegovina and you were engaged in a number of peacekeeping discussions, could you share with us some of those discussions and some of those elements? Was the conflict in Bosnia-Herzegovina framed as a non-international armed conflict, or was it an international armed conflict? Ambassador.
Thank you very much. Perhaps I'll talk a little bit about the context, what's going on in the world today and the applicability of IHL, to ongoing conflicts. For instance, we have conflicts going on, in Palestine, in Ukraine, in Myanmar, which is a little bit under the radar, in the Sudan. And some of these conflicts have been going on for quite some time. And without any apparent solutions in sight. So as Professor Andras was saying earlier, when we were serving as diplomats, that was a good time for multilateral institutions and cooperation. Unfortunately, today is a very difficult time in global affairs. And the very fact that you have these ongoing conflicts to which there seems to be no solution signals the difficulty in arriving at a consensus globally on many of these issues. And in fact, overall, there seems to be some sort of retreat from multilateralism. The United Nations Security Council, for instance, is unable to take serious decisions aimed at ending these conflicts, and more recourse to unilateral actions by member states. So, we have these ongoing conflicts, and you can see the kind of damage that has been wrought. The International Humanitarian Law talks about minimizing civilian losses. It talks about not harming shelters or food sources or energy supplies, not attacking humanitarian convoys, no blockades of food supplies, etc. But many of these things are actually happening in these armed conflicts. So for me, I think, the law is absolutely critical today, much more so perhaps than in the past. But the critical issues are how do you enforce this law? Where are the mechanisms for the enforcement of these laws? And why are these mechanisms, and there are several mechanisms, why are these mechanisms not effective? And so the point I want to bring in here is that in addition to international humanitarian law, the geopolitical circumstances within which international humanitarian law is applied is absolutely critical. And you were speaking about international armed conflicts between states and armed conflicts between states and non-state actors and so on. And in fact, in the current scenario, in the wars that are going on, you can see a combination of these. You have conflicts between states, you have conflicts between state and non-state actors. You have, for instance, in Myanmar, conflict between state and a multiplicity of non-state actors. So it's a very, very complex situation. And I think what is really critical is to find some means of bringing the protagonists together and arriving at a solution. And in the case of Bosnia and Herzegovina, there were several elements within Bosnia and Herzegovina with support from outside fighting, against the Yugoslav government. So for me, what is more interesting is not necessarily the characterization of these armed conflicts, which is interesting from an academic point of view. But for me, the complexity of the conflict and finding solutions becomes that much more difficult when you have a whole lot of non-state actors at play. Perhaps resolution of disputes between states may be easier to manage. I'm not sure of that, but certainly resolution of conflicts that involve a multiplicity of actors becomes that much more complicated. So I think two questions that for me are very important. One, does the international humanitarian law as we have it today, is that adequate to take into account the new forms of conflict, new forms of warfare that exist? Also, for instance, there is this feeling that non-state actors take shelter behind civilian populations, or say in hospitals and educational institutions. So are those valid targets under international humanitarian law? And secondly, the all-important question from my perspective is, how do you resolve, or how do you enforce international humanitarian law in given circumstances? For instance, one example, there have been a lot of indictments by the International Criminal Court against very senior people in some of the armed conflicts that we have today. But individual countries, even those that have ratified the charter of the ICC, have said that they will not implement it. There's a lot of geopolitics in that. And I think I do want to stress this, especially for the participants, that you have the law, but you have geopolitics, and it's the two together that really decide the course of action or the outcomes.
Thank you very much, Ambassador Ray. And Professor Vamos-Goldman, if I could ask you, so what was the trigger events that led up to so much of the quote-unquote non-respect or the dysfunctionment of the multilateral system? Because again, if I stand to be corrected, but IHL is designed to prohibit the use and the means of the methods of warfare, and all those that are signatory to the Hague and the Geneva Conventions, the additional protocols that are specific to the nature, to the cause of, to prevent superfluous injury. And there are three core principles. That is to make the distinction between what is a legitimate military target, and those elements, schools, religious, cultural, civilians that need to be protected, the element of proportionality, and then the element of precaution. So there's a two-pronged question there for you, Professor Vamos-Goldman, please.
Thank you again. And first, let me say that I very much agree, Ambassador Ray, with your characterization of the situation today. That there is a real dichotomy between the multilateral application of some of our rules and how we conceptualize some of our rules. And I think maybe we need to, and to answer both of the questions that have just been posed, I think we have to take maybe a step or two back and try to understand why we have international law. International laws like international humanitarian law. What purpose does it serve? How does it help us regulate a rules-based international system? And the way I often try to portray this is that the international law, and in our present case, international humanitarian law, stands as a foundation for that rules-based system. So if you think about it in the same way as you're building a house, if you're building a house with a solid foundation, then your house is likely to be able to stand and withstand bad weather, climate change, the wolf coming to huff and puff and blow it down. So long as the foundation is strong, the system, the rules-based system, will be strong. What makes the foundation strong? I think, as you said, it's really based on respect. If we respect the rules, if we respect the laws that we have created, the laws that we have either agreed to explicitly in treaties and conventions, or implicitly through our practice and belief that they are international law, so they become customary international law, then we are building a solid foundation for a rules-based system. We're also providing an example for other states and other actors, other international actors, not just states. Today, we can't just say that states are the only international actors. We have so many corporations, non-governmental organizations, special interest groups that are part of multilateral action. I think in some cases we should have, I think we would be much better off having even more subnational units, cities, states, provinces. There was a time, again, that Ambassador Ray was mentioning, when multilateralism was more effective and also more, I have to say, respected, where actors such as mayors of cities and governors of states and provinces were able to participate. I think that kind of interaction would help strengthen the rule of law. So where did it weaken? How did we get to this situation? I mean, this is a very complex question, and is actually a political question, not a legal question in the sense, but I'm happy to give you my view. And I think we have progressively, when the horizons with which we have started to look at human progress domestically and internationally began to be shorter and shorter and shorter. When politicians, as opposed to statesmen and stateswomen, started to take over the running of states, the running of international institutions, when their horizons were to the next election or the next news cycle even, and not what are the challenges that are facing us and facing the world, then we began to slip into this, we must do whatever it takes, whatever we have to do now to fix the situation in the public eye. That's not necessarily the same as fixing or trying to address the situation. So we are facing a lot of challenges today that we are not even acknowledging. We are looking at we are in words acknowledging climate change, but we're not acknowledging it in deeds. We are not even acknowledging the challenge of AI, which actually doesn't stand for, or should not stand for, artificial intelligence. It should stand for alien intelligence, because we are not creating intelligence that is going to be like human intelligence. This is not a new version of human intelligence, which would be artificial intelligence. This is something completely new. Very few people actually understand today the implications that we're going to be faced with. So the answer to the question, I think, that Ambassador asked is, are we ready with international humanitarian law to face upcoming challenges? The answer is absolutely not. Absolutely, not only in international humanitarian law, in other areas as well. But it's very telling, actually, that the last amendments to the Geneva Conventions were in 1977. And I know that Switzerland, who is the custodian of the Geneva Conventions, has in the past tried a number of times, or certainly contemplated a number of times, to see if we could do some more updates to the Geneva Conventions. And the concern, and the reason why it hasn't happened, again, in my view, is the concern that if you open them up, if you open up the Geneva Conventions, you might actually end up with a product that is not even as good, and not even as complete, not even as strong as we have today. And that's because we're not looking forward, we're not looking ahead to meet upcoming challenges. Our leadership today and over the last number of decades seem to have been more concerned with meeting the demands of the next news cycle or the next set of elections. And I think until we change that, until that is altered, and we do have some far forward-looking leadership, I think we're going to be stuck in the current situation.
Thank you so much, Professor Vamos-Goldman. I see Ambassador Ray would like to build on some of the elements. So without any delay, Ambassador, you have the word back.
Thank you. I think what Professor Andras has said is very, very interesting. Why are we here today where we are at such a difficult moment in international affairs? And I agree with what he has said, and I just want to add one more element to that. And I think all this started with the financial crisis of 2008 and this huge pushback against globalization. This feeling that globalization has benefited some countries and has actually harmed other countries. Jobs have, moved abroad and so on. So there was, this feeling or a development of a more insular personality for some of the larger countries. And, there was this policy of my country first. Today, for instance, we see this talk of tariffs. So it's actually the world retreating or breaking up little, it's becoming much more fragmentary. And I think the implications of this you see in the functioning of the United Nations Security Council, and, even, for instance, during the COVID pandemic, the role of the United Nations, and so on. So it's a very difficult time. And a lot of it, as Professor Vamos-Goldman said, has to do with the news cycle and interests of individual political leaders, many of whom are in the largest countries. The second point I did want to make, and this is something that has also, I've always questioned it myself, not being an expert on international humanitarian law, but I'll give you an example of the peace process in Nepal. Nepal was plagued by a Maoist insurgency for 10 years, and 17,000 people had been killed by the insurgents and by the military. And when this peace process started, and I was associated with it, there was this whole question of how do you deal with the crimes that have been committed. On the one hand, you have to negotiate with the belligerents, that is the Maoists. On the other hand, they also there needs to be justice for the crimes that they have committed. But how do you begin negotiations unless there is some understanding, given to the belligerents that they will not be arrested or they will not be imprisoned? So, you make certain compromises with international humanitarian law, and then you say, okay, perhaps certain types of heinous crimes will be adjudicated, and perhaps others won't be. Maybe the top leaders of the movement will not be tried. So it becomes very complex. and as as somebody who's involved in the day-to-day politics, so you really have to weigh the pros and cons. I mean, is the peace more important, or do we have to adhere to the to the letter and spirit of international humanitarian law? And these are issues that you juggle with when you're involved in these peace negotiations. And I was wondering, perhaps Professor Andras, I mean, here I'm being a student really. How do you handle these? How do you handle these very complex issues?
Thank you so much, Ambassador Ray. And Professor Andras Vamos-Goldman, I'm going to ask you to respond, but I would like to add another element, is to say, what we see now is how certain nation states hang on to that notion of absolute power and not wanting to necessarily contribute to the international system, and then using bilateral means, as both of you have said before. So I'd like you to respond on that, and then kindly ask you both. Then after we have the response from Professor Vamos-Goldman, I will draw on some of the questions that some of the participants posed. So Professor Vamos-Goldman.
Thank you. Ambassador Ray, I really agree with your addition to my comments. That is very much the picture that today internationally. To your question specifically, we have to then delve into the realms of international criminal law, because the responsibility, although states absolutely carry responsibility for fulfilling international humanitarian law, part of that responsibility is ensuring that those who are responsible for breaches of international humanitarian law, the individuals who are responsible for breaches of international humanitarian law, are brought to justice. And you are absolutely right. If you have a situation, a conflict situation, in which the resolution of which does not include justice as part of the remedy, that conflict is almost certainly going to, history tells us, statistics tells us, that conflict is always almost certainly going to rekindle. So you really do need to have justice as part of the remedy to the conclusion of those conflicts. But the responsibility, international humanitarian law imposes a responsibility on states to bring the individuals who've committed, or who have ordered, or who have permitted the commission of breaches of international humanitarian law to justice. And when the state is unable or unwilling to do so, that is when the international community kicks in the form of those of us who were part of bringing about the Rome Statute for the International Criminal Court. We had hoped that there would be a comprehensive global international criminal court for those times when states are either unable or unwilling to investigate and prosecute those who breached international humanitarian law, normally referred to as core international crimes. These are genocide, war crimes, crimes against humanity, and to some extent also the crime of aggression. Why individual responsibility? Why is it important to have the individual, as opposed to not just the state, held responsible? Because, again, ever since the end of World War II and the Nuremberg and Tokyo tribunals, it's been recognized that if you are going to have deterrence, to deter people from ordering or committing or permitting under their authority to have for these crimes to happen, individual responsibility is necessary. It is not possible. It should not be possible to hide behind, I was only working for the state, I was only following orders, it's not me, it's not the state. How do you bring a state to court? How do you extract justice from a state? It is much more effective to do so with individuals. But how do you do that? As Ambassador Ray absolutely correctly asked, how do you do that in the context of conflicts that involve thousands and thousands of people who might have been responsible, and justice institutions that are not necessarily able to carry this much, such a burden? Prosecutorial practice in the Yugoslavia Tribunal, the Rwanda Tribunal, the Sierra Leone Special Court, and now the International Criminal Court has been that those courts are going to be responsible for those persons bearing the greatest responsibility, and only those persons bearing the greatest responsibility. Because if you prosecute the soldier who pulled the trigger, you're not bringing justice to the victims, and you're not bringing closure to the situation. If you are able to prosecute the person who ultimately gave the orders, or who ultimately permitted these acts to happen because they wanted to, or there was through their negligence, you're much more likely to bring closure to the situation. So I'm hoping I'm answered your question. Mr. Moderator, I'm not sure if there was time to answer your second question, and maybe we'll find time in one of the Q&As to do so.
Thank you so much. I'm going to open the floor now, and a number of statements concluding with a question focus on a number of some of the current wars that is going on, and one where ballistic missiles are being used to target civilian facilities. And the question is, what can the international community do to address this ongoing violence targeting civilians? And I would ask Ambassador Ray to potentially share some comments, and for instance, some of the work that the United Nations Institute for Training and Research is doing to advocate for peace and security. And then I would ask you, Professor Vamos Goldman, to share some of your insights. Ambassador Ray.
Yeah, thank you. And this is really a very critical question, because the law will be applicable only if you have enforcement mechanisms. And we do have enforcement mechanisms, whether the United Nations Security Council or the General Assembly or the various, the ICC and the tribunals. So there are enforcement mechanisms. But even the applicability of these mechanisms really depends on some kind of political consensus. So if governments are not willing to act, and if say permanent members of the Security Council are involved in a conflict, then they have veto powers. So obviously the Security Council cannot take a view, cannot decide. So what do? Perhaps you go to the General Assembly, perhaps you go to the people, you raise public opinion. I mean, we have seen, for instance, in the ongoing conflicts, how public opinion the world over has been so agitated and is trying to pressurize governments into taking action and doing something. So this becomes the problem of geopolitics that I was mentioning earlier. And it's a very difficult response. I mean, you can quibble over whether, crimes against humanity have been committed or not, but I think the evidence is there to see everyone knows that there have been gross violations of international humanitarian law. And unfortunately, there has been no reckoning of this for geopolitical reasons. And, I'm at a bit of a loss, and I really think the only way perhaps is for the people themselves to put pressure on their own governments and influence the decision making of their governments if the existing institutions are incapable of taking action because of geopolitical reasons.
Thank you very much, Ambassador Ray, for that really insightful answer that also reminds us that the people have a lot of power and influence that they can execute, and specifically during elections, and the element of natural law that also plays into this. Thank you so much, Ambassador. Professor Vamos-Goldman.
Let me maybe add one other possibility to addressing this situation, because as far back as the creation of the United Nations Charter, the world has set up a system of collective security that, as we know, is predicated upon the work of the Security Council. Now, we've all noted that the Security Council was largely deadlocked during the Cold War, basically until the 1990s, from 1946 to the 1990s, and then again from a couple of years or a few years after maybe just to set a benchmark, after 9/11 again started to be deadlocked. It wasn't deadlocked immediately, but then the process had set in, and it is certainly deadlocked now. And because it's the Security Council that's charged with maintaining international peace and security, therefore acting on behalf of all UN member states to exercise collective security, if it doesn't work, then we are in the situation that we are in today, that we are unable to enforce, for example, international humanitarian law rules, and protect persons who are supposed to be protected in times of conflict, or not to have conflicts that are not supposed to, or that are not authorized according to the Charter. We assume that because of the veto power, the Security Council will remain deadlocked if one or more of the permanent members are unwilling to, in whatever situation, whether it's one of their vital interests or whether it's one of their client states' vital interest, to act. But I think we miss a point, and that point is that there are two different kinds of vetoes. Actually, there's the veto where that is a state casts, a permanent member casts, in protection of its own vital interests, and that could be as broad as possible. And of course, permanent members will cast it that way. There's another kind of veto, and the veto that is very specifically involved in international humanitarian law issues, because if atrocities are happening, so core international crimes, genocide, war crimes, crimes against humanity are actually taking place, and there are enough votes on the UN Security Council to stop or prevent these actions, then under a number of currently existing international law rules, blocking that Security Council action by a permanent member is actually ultra vires. It's something that we are only beginning to address now. A colleague of mine at New York University, where I teach, has written a book about the veto that is cast in the face of atrocity crimes that directly prevents Security Council action. It contravenes the Jus Cogens norms, because we're not supposed to take action that perpetrates Jus Cogens, which are the highest levels of international law, such as prevention of genocide, for example. I mean, we're not supposed to take actions that allow genocide to happen. Yet casting a vote to stop the Security Council from stopping a genocide from happening is actually contrary to Jus Cogens rules. The UN Charter, the purposes and principles of the UN Charter should be paramount. So there's no one section of the United Nations Charter, not even the section that permits vetoes to be cast, section 27.3, should be able to contravene the purposes and principles of the UN Charter. And protecting international peace and security is definitely part of that. And then there are specific treaties and conventions, like, for example, the Genocide Convention, which compel states parties to that convention to make sure when genocide is happening, to take action. So in order to, if an action is taken to actually block the prevention or stopping of a genocide, that again is against international law. So I think we can explore legal rules that allow the UN Security Council to be more flexible, because when a veto is cast or even threatened in the face of core international crimes, those vetoes should be ultra vires. And if they are, then the Security Council will actually become more active and be able to exercise collective security. Thank you.
Thank you so much, gentlemen. We have 5 minutes left, so I would kindly ask each one of you to use around a minute, minute and a half to conclude the discussion. And if there would be one parting message of action that we can take, what would that be? Ambassador Ray, you have the word.
Thank you. For me, the upholding international humanitarian law during conflict is absolutely vital. And if existing institutions are not able to enforce international humanitarian law, we must explore every other means of doing so, of pressurizing member states. And, you know, as I was saying earlier, the voice of the people is very, very strong and very powerful. So I do want to say that we should not be despondent. We're living in very difficult times with a lot of conflicts, but this is the challenge. In these circumstances, it becomes even more important to ensure that international humanitarian law principles and rules are abided by all states. And secondly, all this must be documented. And all these violations must be documented. If not today, there will be justice in the future. And we have the technological capabilities and the means to do so. So I think this will also be a very important deterrence for the future.
Thank you so much, Ambassador. Professor Varmus-Goldman?
I entirely agree with Ambassador Ray. And I maybe just to add that he or she who does not take care of their home will soon see their home deteriorate and fall apart. This is the lesson that we need to take from the situation today. If we are not willing to take care of multilateralism, if we're not willing to show respect for the rules that we have established and we have agreed to have a rules-based functioning system that allows us to live in peace and go forward in prosperity, then we're going to reap the results of our actions. So the most important thing for us to remember is that we need to show respect for the rules that we've established. We need to understand that they form the foundation of our system. If we don't respect them, we cannot expect others to respect them. And we see the consequences of that. So even if it seems convenient to ignore a rule because it will look better in the next news cycle, please remember, world leaders, international institution leaders, that in the long run, a solid foundation of a rule of international law serves a strong rules-based international system.
Thank you very much, gentlemen. I think that is such a powerful message to conclude with, is our individual responsibility to continue to construct the importance and the necessity of an international rule-based system. So thank you very much. But a equally big thank you and sign of appreciation goes to all those members of the diplomatic community, of the academic community, the safety and security, defense, entities who have joined today, students, scholars, religious leaders. Thank you so much for taking an hour out of your schedule and to listen to both Ambassador Ray and Professor Andras Vamos-Goldman. And allow me, please, and join me to thank both gentlemen, because what just resonated throughout this conversation was just such a brilliant example that both our speakers demonstrated, and that is human-centered leadership. So we wish to thank you both sincerely for engaging with us during this interesting conversation. And rest assured, we're going to be knocking on your door next year to take this conversation forward. Thank you so much, gentlemen. And thank you, everybody, for joining us. Thank you.
Thank you.